qualifying for Medicaid. And before I do that, though, I just want to spend a couple minutes talking about what Medicaid is. So Medicaid is a federal program. It's administered by the states. So if you cross state lines, there could be differences as to, various qualifications and what have you and benefits offered. But most importantly, one of the things I also want to clarify is that Medicare does not pay for long-term care. So for many of my clients, they often look to us to help them get on Medicaid so that they don't lose all of their assets to long-term care, because unfortunately, most people, approximately 90% of the population, the overwhelming majority, I guess, of the population does not have long-term care. And since, again, Medicare doesn't pay for long-term care, if you end up needing long-term care, statistically, there's a high probability you will, then, you either have to pay out of pocket or you're going to have to plan to get on Medicaid. Okay. So one of the other things I also talk to my clients about is Medicaid planning is really a 4-letter word. And sometimes I get some crazy answers, but the most important answer is it's all about math. And why do I say that? Because essentially Congress doesn't want people to give away all their assets and get on Medicaid tomorrow. So there is a 60-month look back period. No state can have it longer than 60 months because the federal government, Congress has stated that the look back period is 60 months. And so under the supremacy clause, that's as long as it can be. My understanding is that California may have a 30-month look back period. But for my clients here in Florida and New Jersey and Florida both have a 60-month look back period. And so, again, that's just an important concept to keep in mind. One of the other things, too, before I go on about qualifying for Medicaid, is one of the things I preach to my clients is it's not necessarily how much money you have, because one of the myths that I often get from clients initially is, well, I'll never qualify for Medicaid, I have too much money. Well, the law allows us to do certain planning that would actually get you qualified for Medicaid. So, but that's something that we're not going to get into today, but in another session. Okay, so finally, then Medicaid planning is all about proper planning, and again, not necessarily your net worth. So qualifying for Medicaid basically has 5 tests. The first 2 generally are like, the math questions you have in grammar school or high school. They give you a couple of, givens and you have to solve for the rest. So the first 2 are that you're a U.S. citizen and a state resident. If you are a green card holder, you must have been in the U.S. for 5 years before you meet that test. And the federal government basically says that if somebody crossed state lines and as soon as they become a resident, they can qualify for Medicaid. There's not a waiting period. So like, for example, some states will have a waiting period before you can, get married or get divorced. And so, or I should say really get divorced. The other 3 tests then are, really what we talk about with our clients, one of which is clinical, all right? And so to date, I've not had a client not qualify for Medicaid because of not meeting a clinical test. And the clinical test tells us that the individual can't perform 3 of the 6 activities of daily living. And those activities of daily living are eating, bathing, getting dressed, toileting, transferring, and continence issues. So again, I've never had a client that hasn't qualified for Medicaid because they weren't clinically eligible. If you have long-term care or if you looked into long-term care, typically the long-term care policy will kick in when you can't do 2 of the 6 activities of daily living. But for Medicaid, it's 3 of the 6 activities of daily living, that if you can't perform 3 of those activities, then you would be clinically eligible. And generally that assessment is done by a nurse and sent back to Medicaid as part of the overall application and approval process. So really that leaves 2 tests that are financial in nature. And again, through what the law allows us to do, we can actually control those two tests. The first is a income test. So both Florida and New Jersey are income cap, what's called an income cap state. And currently that means that a applicant can't have more than $2,382 of gross income, all right? So that's before withholding, it's before your Medicare premium. So your gross income. Now you may be saying, well, I'm over that. And yes, 95% plus of our clients are over the income threshold, particularly since where we have our offices and those locations are, high rent districts, to say the least. So to able to live and survive in those areas of the country, you do have to have a certain amount of gross income. So if your income is over that threshold, which again, most of my clients are, then we would have to set up something called a qualified income trust. It's also known as a Miller Trust. And depending upon whether you're in New Jersey or Florida, there's different rules about what has to get funded into the trust, but the result is the same. The trust acts as basically a mechanism that's a control mechanism to make sure that the person's income is in fact going to their cost of care, because Medicaid is what is referred to as a payer of last resort. So even for our clients that do end up on Medicaid, they still have to pay a certain amount of their income each month towards their cost of care. And so that brings up another point. There's something called the Spousal Impoverishment Act. And, I tell people, think of it as when Congress woke up and had a V8 moment, right? It used to be that the rules were so stringent that even if one spouse qualified, the other spouse would end up being destitute because they were still well and didn't need care. So as a result of the Spousal Impoverishment Act, there's two pieces to it really that are important to our clients. One is the income piece. So if you have one spouse that goes into, a nursing home or assisted living, as the case may be, and they get on Medicaid, and there's still a spouse staying at home, what we call the well spouse, some or, not all, but a good chunk of the spouse that needs care, their income can be reallocated back to the well spouse, so that the well spouse, which is also called the community spouse, would be able to stay in the community, because that's the goal, and be able to live their life without being destitute. So again, there's a piece of that related to the income. That's the income piece. On the asset side, before I talk about the asset threshold, with respect to the Spousal Impoverishment Act, it's called the Community Spouse Resource Allowance. And what that does is it exempts a certain amount of assets that the well spouse can keep. So again, they can stay in the house. So assets that would otherwise be non-exempt assets and would disqualify a person potentially for Medicaid are treated as exempt so that the well spouse can stay at home. Okay. So on the asset side, though, if you basically have one person applying, a single person, it's a $2,000 threshold. So that person cannot have more than $2,000 of assets in their name at the time they apply, and for every month thereafter, so long as they are on Medicaid. Okay, it's a very important number, and that's a number we, go over for our clients all the time. I tell them repeatedly, make sure at the end of the month that, it's mom or dad, your aunt or uncle, whoever it is, that they don't have more than $2,000 in the bank. Okay. And it's also very important. Many clients will have multiple bank accounts. I always recommend to whittle that down to preferably just one account. So you're only worried about managing one account and not having other accounts where it leads to a greater opportunity to have a foot fault, to use a tennis analogy. And all of a sudden, the person ends up being disqualified. Okay. So again, on the asset side, the two important concepts are the person applying can't have more than $2,000 in their name. And then if you have a married couple, and typically, as is the case, one spouse is not ready for long-term care, then the community spouse resource allowance would convert what would otherwise be non-exempt assets into exempt assets so that the well spouse can continue to reside at home. If you have any questions, please feel free to reach out to us. We'd love to speak to you about your situation and help you. Thank you.